Hello, my name is Nina Callan. I'm a Massachusetts attorney specializing in bad faith and coverage claims with respect to liability insurance. Today, I'm going to talk about a couple of duties that an insurer has when a policyholder is sued. The first duty is called the duty to defend, and the second duty is called the duty to indemnify. The duty to defend means that if someone with insurance is sued, the insurance company needs to hire an attorney to represent them in the lawsuit. So, for example, if you as a policyholder cause a car accident, you run a red light, run a stop sign, just not paying attention, you cause a car accident and you injure someone, and the injured person, who we call the plaintiff, sues you, you notify your insurance company that you've been sued. The insurance company is required to hire an attorney and pay that attorney's fees to defend you in that lawsuit. That's called the duty to defend. The second duty that an insurance company has is called the duty to indemnify. That means that at the end of the lawsuit, when there's been a settlement or perhaps a judgment against you, the insurance company has the duty to pay that settlement or judgment on your behalf. Now, sometimes an insurance company may have a duty to defend, but not a duty to indemnify. And I'm going to talk about when those duties arise and what happens when there's potentially a different outcome for the duty to defend than from the duty to indemnify. The duty to defend is determined by, sometimes we call it the four-corner test or the eight-corner test, but it's determined by comparing what the plaintiff alleges in the complaint to what the insurance policy says that it covers. So, for example, going back to the simple car accident, you may be sued as a driver of a car, and the complaint against you might have two separate counts. The first count might say that you negligently or accidentally caused a car accident, resulting in the plaintiff being injured. The second count might say that you intentionally caused the car accident, that you intended to run this person over. And those would be pleaded in the alternative, negligence or on purpose. The negligence count is covered by the policy. Negligence is pretty much always a covered loss, but an intentional battery, you intended to hurt someone, is generally not covered by the policy. So different states have different rules on this, but in Massachusetts, if there is any count that is covered by the policy or is potentially covered by the policy, the insurer has a duty to defend you in that lawsuit, again, to pay for your attorney. However, whether or not the insurer has the duty to indemnify will depend on, once there is an end to the lawsuit, what is determined about how this accident happened. If the determination is that you negligently caused this accident, then there's coverage and the insurer will pay the damages which are determined up to its policy limit. But if at the end of the lawsuit it's determined that you intentionally ran this poor person over, then there's no coverage under the lawsuit. Again, that type of loss would be excluded under the policy. In that case, the insurer would have, again, no duty to indemnify and would not pay the loss, and you'd be required to pay the loss. Again, you've come out ahead by having insurance and that you haven't paid attorney's fees, which a lot of times can be more than the damages which are actually suffered by the plaintiff. So that's a really important reason to always have good insurance. At the beginning of a case, if an insurer determines that there is a duty to defend, but there may not be a duty to indemnify, again, it's going to depend on how the facts come out as the lawsuit develops, it may issue what's called a reservation of rights letter. That reservation of rights letter will say, "Dear policyholder, we're going to undertake to defend you by hiring an attorney, but we're going to hold off on deciding whether we have a duty to indemnify you until we see how the facts play out." If that happens, then the policyholder who receives that reservation of rights letter has the opportunity to choose their own attorney, who will then be paid by the insurance company. There is some good reasons to do that. First of all, you want to make sure that the attorney that you choose is competent, and the attorney will certainly push back on someone who's not. But you also need to do your due diligence to make sure that whoever you choose is someone who has the skills and the experience to defend you in a personal injury lawsuit, for example. But you also want to choose someone who can undertake the defense in such a manner as coverage at the end of the case will be more likely. So if you choose not to exercise your right to choose your own attorney to be paid by the insurance company will hire one of their panel counsel who almost always across the board are competent attorneys who know how to defend a lawsuit very well, but they are not allowed to take coverage into account. They cannot work against the insurance company to try to defend the case in such a way that if you are found liable, for example, the liability would be for negligence and not for intentional battery, so that there's coverage at the end. So that's an important reason to exercise your right to choose your own attorney. Those are just a few issues with respect to the duty to defend and the duty to indemnify. Thanks for listening and have a great day.